Right, I see Miss Himes. Some, oh, there she is. Okay. I understand the Appleys have conferred and decided how they want to divide your time.
Yes, Your Honor. Lori Heim, I will begin for the Applees and I will cede 7 minutes of
Okay,
time to Mr. Schmidt. Thank you.
right. Great. Let me make a note. All right. So, Mr. Sanders, you're up.
Thank you. Good morning, Your Honors. May it please the court. My name is Carol Sanders, and I represent the appellant and the plaintiff below, Ms. Michelle Landon. In the big picture, this appeal is about basic fairness. It's fairness in a residential real property transaction and fairness in our civil justice system at large. Substantively, this case is a referendum on Johnson versus Davis. If the appellees and lower court's interpretation and application of Johnson and its progeny is upheld, then the disclosure requirement imposed on sellers and their agent brokers is basically.
Let me just interrupt you right there, Mr. Sanders, because it was the fireplace was disclosed. So why don't you start with that?
The fireplace, well,
Yes,
it was not disclosed that it was concealed and walled off.
it was in the MLS listing. She just didn't bother to read it.
Well, respectfully, Your Honor, there's no
And
requirement.
there's a chimney. There's a chimney that's
Okay.
plainly visible.
Well, a couple things, Your Honor. Respectfully, there's nothing in Florida law that says that you're charged with knowledge of what's in the MLS or that you're required to read the MLS. Now, there was also a seller's disclosure.
Well, but you know what? If you're going to allege that something wasn't disclosed and you haven't read anything, that's a problem.
Well, I would submit that it's fairly common in this day and age where buyers go on sites like Zillow, for example, find the homes that they want to see, and then submit the address to their agent to set up a showing, which is exactly what Ms. Landon testified that she did here. So there's nothing out of the ordinary about her, not looking at.
Look, she was provided with the information. She elected to rely on Zillow and whatever else she looked at. I read her testimony. I've read this transcript. She elected not to inform herself.
I would disagree, Your Honor, respectfully. She had a.
No, I understand you disagree, but what the record to me is very clear that this information was provided to her, but she just chose not to look at it for whatever reason. And even her agent wasn't aware of it. And
right. Neither
there was a chimney. There was a chimney. I mean, you're not going to, I don't know how. I don't think you can convince me. I can't speak for my colleagues that there was a non-disclosure here. But even if I wanted to give you that, where is the evidence in this trial of damages?
Your Honor, the damages, the evidence of damages are in the form of photographs showing what Ms. Landon
I understand you put in evidence of photographs, but there was no testimony as to what monetary value could have been placed on the damages she claims were caused by this non-disclosure.
Well, respectfully, Judge, under Johnson versus Davis, that's not a requirement. The requirement is to show materiality, and we would submit that it was at least worthy.
So the jury can just pick a number out of the air? That's the law?
Well, I've cited support under Florida law in my brief for the proposition that the jury can exercise common knowledge on matters that are within the.
So it's common knowledge how much it costs to rip out a wall and replace all that stuff. That's common knowledge.
Well, Your Honor,
common knowledge what was caused by the non-disclosure?
Your Honor, I would submit to you that prior to beginning the trial, we asked potential jurors extensive questions, and from recollection, I believe just about every one of them, if not every one, purported to be a homeowner or have recently, within the last 5 years, purchased or sold.
So your position is under Florida law, you do not have to offer any evidence. You don't have to quantify the value of damages. The jury is free to speculate based on, quote, common knowledge. They don't have to have a dollar figure to work with. They can just pick something out of the air. You've got, what, 6 different jurors? What if they all have different experience?
Well, in some cases that might apply, Your Honor, but I would also submit part of the appeal here is the way that the trial was handled. All parties were aware at the outset of the trial that Ms. Landon's expert witness at the last minute was unable to appear. So we were actively trying to get a replacement. Ms. Heim even
That is not apparent on the record in this case. I've read it.
Judge, it
Can
would
you-
be in
maybe
the,
I missed it. Can you direct me to where I would find information about that in the record?
certainly it's on the transcript of the trial.
Because the way I read it, you rested your case after calling 2 witnesses.
Well, there's a lot of facts and circumstances that surround that too. But just to go back to the kind of the beginning of the trial, day one, before we started, we moved for a continuance because of both not having the expert witness and Miss Landon's mother being on death's doorstep with breast cancer. Both were denied, which is fine, but all parties knew that we were actively trying to recruit a new expert witness who could come in and testify to the amount of damages, who could, authenticate
As
the
I
receipts.
recall your argument
Mhm.
at trial, when this discussion came up with the trial court, your
Mhm.
position was you didn't need any more than what you had offered. That the pictures and the testimony was sufficient to establish your damages.
Well, I believe my point was that it was sufficient to avoid directed verdict, but it was never the intent to stop there. Now, as you know from my brief and the transcript, we approached the bench at approximately 4:30 towards the end of day 2. I have chronic migraine headaches. I was suffering the onset of
Right,
one. I
right.
explained to the court that I was having trouble even seeing. All I wanted was to be able to go home less than 30 minutes early. And the court represented to me on multiple times that if we did that, if we went ahead and rested, that we would resume and pick up the trial the next day. Now, call me incompetent. I was not in the right position to make the kind of decision that the judge was pressing me to make, which is improper under the law, for the judge to even suggest that we go ahead and rest. And then to follow that up by, me being operating under the belief that we were going to resume the next day and reopen plaintiff's case whenever we were able to get the expert in place and for Ms. Heim to depose them. That was kind of my expectation of what was going to happen. To my surprise, as soon as the jury was released, the judge looked at the opposing counsel and said, does anybody want to file a motion? That's also improper, to suggest the course of action for a party to take. The trial, that day 2 trial, should have been dismissed at that time, just a few minutes ahead of schedule, and we could have picked up the next day. And it was due to my physical condition that all parties knew about, and nobody doubted or questioned or anything else, that the things played out the way they did from there. Certainly, had we gone on, we were definitely going to question Ms. McGinley, Ms. Perry, Mr. Doyle, the home inspector, and a prospective expert witness that would have shed more light on the specifics of the dollar amounts involved with Ms. Landon's home repairs. We didn't get the chance to do that. So effectively—
Why did you rest your case? I'm not clear on that. Are you saying you were forced to rest your case? Because that's not how I read the transcript. So
Well, I
could
wasn't
you
forced.
elaborate on that?
I wouldn't say that I was forced, Your Honor. But what happened was I approached asking to cut out for the day
Right,
less than 30
right.
minutes early because of my physical condition.
Right.
The judge followed that statement up by asking the parties, the attorneys for the other side as well, what was the roadmap for everybody's remaining days of trial, which I did the best I could under the circumstances. I laid out who else I needed to question, suggested that one of them, Ms. Perry, I could get what I needed from her on cross. But it was still known that we needed to, at a minimum, question Mr. Doyle and Mrs. McGinley. So, and potentially an expert witness. So when I rested, it was on the judge's suggestion that, well, if you go ahead and rest, we can cut out early today and we'll pick up tomorrow and resume the trial. But the way things played out would suggest that there was never any attempt for that to happen, because as soon as we rested and the jury was dismissed, she immediately asked for motion.
Sir, if I understand correctly, when you rest, that means you're finished calling witnesses, right?
Yes.
So what I
subject
think
to—
what she was referring to is we can pick up is any arguments on motions and then put on the defense case.
And maybe she did, but I would submit that in
Well,
my
what else
condition—
could it mean?
Well, in my
I mean, does
compromised
resting imply to you that you're going to be allowed to call witnesses again?
Well, certainly you can request to reopen your case, which
Did
I
you
attempted
request
to do,
to
but I was shut.
reopen?
I was trying to do that before the judge rendered the decision, but she shot me down and ordered me to sit down.
It
and
seems
shut
like
up
to
and—
me what you did was try to talk about deposition testimony, and she got all over you for that. You tried twice. after
Right.
she instructed you not to argue evidence from depositions that had not been introduced into evidence at trial.
Well, that's
And weren't
another-
there also exhibits that you tried to rely on that weren't introduced into evidence either?
Well, that's part of my argument for reversing the decisions, Judge, is that the wrong evidentiary decisions were made, and I spoke to those specific points more thoroughly in my brief. But namely, I would submit the Massey records was one of the bigger problems we encountered. This was arguably smoking gun evidence of knowledge of the latent defects that play here, and the judge for about, I want to say 6 months. Since we first brought that to the court's attention, kept saying, we're going to rule on it, we're going to rule on it. The last hearing we had before the trial, she said, and I'm paraphrasing, that she expects they will come into evidence. Fast forward day 2 of trial, after lunch, we finally get a decision, and she's not going to allow the evidence that she had suggested she would allow. So this really put Ms. Landon in a very untenable position to have to recast her whole case. That was a big piece of evidence that was disallowed. Likewise, we had additional pictures of the damages that were encountered and the area surrounding the fireplace that were deemed irrelevant and not admitted, when in fact they were pictures of the very damages that brought us here for trial.
Well, there was a document in the record that I believe I can't recall if it's in evidence or not, where it actually says that the fireplace is walled off. That may not have made it into evidence.
It didn't, Your
But
Honor.
it shows that it was disclosed, but
Well,
the MLS clearly discloses that there's a fireplace and there's a chimney.
So going back to those points, first, I would submit that a buyer looking at a beachside home in Central Florida, Southwestern Florida, is not even in the mindset of a fire. They're not looking up 3 flights to see if there's a chimney. And we proffered multiple photographs that show from a reasonable inspection of the front of the property ground level, there's no indication of the fireplace, or the chimney, rather, on the roof. And Ms. McGinley even testified in her deposition that, well, if I'm standing at ground level, I'm not looking up, the implication being I'm not going to see the chimney if I'm on ground level, and there's no reason for me to look up. Now, Ms. Perry also testified.
And your position is that putting the existence of a fireplace in the MLS listing does not constitute a disclosure.
Well, maybe it does, maybe it doesn't, but Ms. Landon didn't
Well,
see
wait,
it.
no. Is it a disclosure or not?
Well, no, not in this case, because it did not disclose that the fireplace had been concealed or the conditions that lied behind.
Well, if
the
you
false
don't
wall.
see it, but it's on the listing, maybe you ask a question.
Well, she didn't see the listing, Judge. I mean, I don't know what to say.
Well, and whose fault was that?
There's no requirement in the law that a party buying a house is
No,
obligated to look
but
at.
you know what? If she's going to say somebody didn't disclose something,
Mhm.
how can it was disclosed?
But
Just
Johnson
because she
required,
didn't bother to read it does not take away the fact that it was disclosed.
respectfully, Judge, Johnson versus Davis puts the requirement on the seller to disclose to the
And
buyer,
it was disclosed.
not to the buyer. It is undisputed.
It was
that she was
disclosed to
never
the
given-
world.
She was never given advance notice.
She
that
was
there's a
given the
wall-off
MLS listing.
fireplace. Okay, and even in her deposition testimony, Ms. Perry testified that when she was showing the property herself, she made it a point to go show prospective buyers where in the house, this is the wall that the fireplace is behind, because in her words, in the interest of full disclosure, so that there was no confusion, because even if Ms. Landon had seen MLS, it says there's a fireplace. It does not say there's a concealed fireplace. Now, you referenced another MLS listing that we were going to bring into evidence from a prior time when Ms. McGinley listed the property for sale. That different agent, it was about 2006, I think, from memory. That agent put in the MLS listing specifically, there's a fireplace, but it's walled off. To the extent that an MLS can constitute the disclosure required under Johnson, that's arguably sufficient. Here, at best, it's a partial disclosure, and case law says a partial disclosure is non-disclosure. In fact, there was no fireplace for any intent or purpose in the property. When we finally got back to it, it was so dilapidated it had to be removed. So arguably there's misrepresentation at play there. So either it's non-disclosure or it's misrepresentation. And whether they knew about the extent of the defects or not, it was depriving Ms. Landon the opportunity to know that it was there, to check it out for herself. And the photographic evidence makes it clear that even a cursory glance behind that false wall would have disclosed there's something going on back there that requires further investigation. And she never got the chance to do that. So again, as to the MLS listing, I would suggest that if that is deemed sufficient disclosure, then really we've turned Johnson versus Davis into just a tick mark on a checklist that says if you say this, if you say that, you're good. No, the Supreme Court was very clear. This is about fairness in the transaction, justice, equity. And if it's ever in doubt, if it's ever in question, disclose, err on the side of disclosure. Now, Ms. McGinley fell out of seller's property disclosure. That is what a buyer relies on, okay, when they're inquiring into the condition of the house. Also, home inspection. In both cases, no mention of a fireplace in neither the seller's
Excuse me, that's not accurate. There was a mention of the chimney and the fireplace in the inspection report.
No, ma'am. The
Yes, there
inspector,
was.
he did check yes to fireplace, okay, but then if you look below that,
And he
there's
talked
multiple-
about not being able to warrant the condition.
That was, he said not applicable to that, Judge. He made a handwritten note in A where it said fireplace.
I think your
Oh, no.
argument at trial was it was just boilerplate.
Well, the language, the disclaimer language is boilerplate, but he wrote N/A and he testified that meant everything below this is not applicable, including that disclaimer. Ms. Landon had no reason to think she needed to have an additional inspection of a fireplace that she didn't know existed.
Mr. Sanders, you did not mention whether you wanted to reserve rebuttal time, but you're down to just at 5 minutes. So use
I'll go ahead and reserve and yield the rest of my time, then, if that's okay.
That's fine. All right. Ms. Heim?
Yes, good morning. May it please the court. My name is Lori Heim, and I represent the Applees, Danya Perry, Jim White and Associates, Inc., doing business as Century 21, Jim White and Associates, and James R. White Jr. I'll refer to those Applees this morning as the Century 21 Applees. I wanted to address the statements by Judge Kelly with regard to the bench conference that led to appellant resting her case in chief. That exchange, that bench conference exists in the record at 2481 to 2485. Appellant has argued in the brief and at the trial court level in post-trial motions that the trial court engaged in prejudicial error with regard to this bench conference. I want to point out to this panel that after appellant's counsel, Mr. Sanders indicated that he had a migraine, the court responded, "Can we talk about your next witness and what your plan is?" This is at 2481. Mr. Sanders responded, "Certainly, yes." And he then proceeded to say who his next witnesses would be. The court asked any other witnesses. Mr. Sanders at 2482, line 2, responded, "I would speak to Ms. McGinley as well, not nearly as long as Ms. Perry. I'm debating, Your Honor. What I might end up doing, Your Honor, is resting and just addressing what I want to address on cross for theirs. But I haven't had time to think about that decision." The court then made some comments about her schedule for the following day. And Mr. Sanders says at 2483, "So you're saying if we decided to go ahead and rest, that we can cut out today and start tomorrow?" The court responds, "Yes." Mr. Sanders asks for a quick break to confer with his client. And then he comes back at 2484, line 22. "I'm leaning towards just resting. I'm pretty sure I can get what I need out of cross on these remaining folks." The court then took a brief recess, and Mr. Sanders, when that recess ended at record at 2944, Mr. Sanders says, "Your Honor, the plaintiff's side rests and will proceed tomorrow as we discussed." The decision of appellant and her counsel to rest their case in chief after only calling 2 witnesses, as the record demonstrates, was not as the result of any improper suggestions or comments by any counsel or by the court. The court simply asked the parties what the schedule would be for the next day. I responded, Mr. Sanders responded, Mr. Sanders conferred with his client, and the appellant rested her case. In doing so, appellant rested, having presented, Your Honor, Judge Kelly, as you pointed out, with not presenting any evidence of damages. In failing to do so, appellant did not prove an essential element of every single one of her claims. The claims against the Century 21 appellees were breach of statutory duty under 475.278 Florida statutes, negligence, and negligent misrepresentation. In addition to failing to present evidence on the element of damages, appellant also failed to present any evidence in support of the negligent misrepresentation claim. There was no evidence of a misrepresentation of a material fact that any appellee believed to be true, but which was in fact false. Your Honor, Judge Kelly, as you pointed out, the MLS specifically disclosed the existence of a wood-burning fireplace in the living room. There was no evidence presented of what any Century 21 appellee knew or should have known about the condition of the property other than what was in the MLS. There was also no evidence presented of any justified reliance by appellant on the MLS because, Your Honor, as you pointed out, appellant testified she never saw the MLS. The lack of evidence on those three issues was fatal to the negligent misrepresentation claim. Turning to the breach of statutory duty and negligence claims, which were based upon the exact same facts and duties, the appellant did not present any evidence of whether any alleged defect materially affected the value of the property. That element is key to the breach of statutory duty claim. For all of those reasons, the entry of directed verdict in favor of all of the appellees, particularly the Century 21 appellees on those three claims I identified, was proper. I want to turn to appellant's Rule 1.540B motion. That motion was denied by the trial court. We assert that it was properly denied. That motion was based upon appellant arguing that I committed a fraud upon the trial court. I'd like to address that. Those arguments relate to the inspection report that appellant introduced into evidence as Exhibit 9. That inspection report specifically identifies the presence of a chimney. Now, interestingly, Exhibit 9 that appellant introduced, which begins in the record at 1732, it omitted the specific page of the inspection report that identified the check marks for chimney. I identified in the brief that that missing page exists in the record at 319. So Mr. Doyle, in preparing the inspection report, next to chimney, he checked yes. Later in his inspection report, there is the pre-printed language that references a fireplace and a chimney. That pre-printed language, which Mr. Sanders this morning called boilerplate, that pre-printed language instructs a buyer to have a chimney inspection conducted prior to closing. So at trial, in the record at 2893 to 2896, I specifically asked appellant about the report, about the fact that a chimney is identified as existing at the property. And then I turned appellant's attention to the pre-printed language regarding the chimney inspection. And I elicited from appellant that she did not have a chimney inspection conducted prior to closing. All of the attorneys knew going into trial that Mr. Doyle testified that he didn't see the fireplace. He missed it, and he testified in deposition that that pre-printed language that I just referenced should not be read to assume or suggest that he did notice the fireplace, because he testified he didn't. At trial, it would have been improper for me to use that pre-printed language to suggest that the inspector did find the fireplace, because he didn't, and we all knew that. But that's not what I did. At trial, I focused on the chimney, the existence of it, and the fact that pre-printed language instructed the appellant to get a chimney inspection prior to closing, and she failed to do so. I did not commit a fraud upon the trial court. The record is very clear on that fact, and the trial court properly denied appellant's Rule 1.540B motion. Turning to appellant's 1.530 motion, that motion was also properly denied by the trial court. It was not supported by any facts that showed any significant or substantial prejudicial error by the trial court. That motion relates to that bench conference that I addressed at the beginning of my argument today. I won't belabor that point and say it twice, but there was no misconduct by the trial court or any attorney that led to the appellant and her counsel choosing to rest their case without presenting the evidence that I've mentioned earlier. Similarly, the motion to disqualify the trial court was properly denied by the court. The record in this case, over the years-long period that this case was pending, demonstrates that there was no bias by the trial court. Yes, there were rulings that did not go appellant's way at the trial court level. That happens to all of us, but there was nothing to indicate any bias at all. Without question, at the trial court was very direct with appellant's counsel. She was very direct, Judge Kelly, as you pointed out. She was very direct with him when he attempted to introduce as evidence at trial a deposition transcript. I objected to that. That objection was sustained. Mr. Sanders raised that issue again. That did not please the trial court. But there was nothing in her conduct, either at trial or in any pretrial proceeding, that suggests any bias that would warrant a motion to disqualify the trial court. I wanted to turn to the standard of care expert. Appellant's counsel referenced that the conduct of the trial and the decision to rest somehow should be affected by the fact that he was trying to get an expert witness there. And counsel today even suggested that that expert was going to testify as to materiality. That is not accurate. The expert witness that Mr. Sanders did not subpoena and who did not appear at trial was a standard of care, a real estate broker expert, not an appraiser, not a contractor. So that is not an expert that would have been able to provide the missing evidence as to whether or not any fact at issue materially affected the value of the property. Appellant's counsel today suggested that because appellant's mother was very ill, that that somehow should affect the outcome of this appeal. The trial court was very clear and told appellant and her counsel that if appellant for any reason needed to leave during the proceedings to tend to her mother, she was free to do that. The trial then proceeded without objection by appellant or her counsel, and in fact, appellant attended the entire trial. So again, there was just a monumental failure in this case of the appellant to introduce into evidence at trial the basic evidence necessary to prove the elements of her claims. If there is any questions by the panel, I'll be happy to answer those. Otherwise, I will conclude my arguments. Thank you.
Okay, thank you, Ms. Heim. You've left an additional minute for your report. So, Mr. Schmidt, you have 8 minutes.
Thank you. Good morning, Your Honors, and may it please the court. My name is Ryan Schmidt. I'm the counsel for appellee Marilyn McGinley. Initially, I would just like to concur and join in all arguments made by Ms. Heim as to each of the issues on appeal asserted, which pertain to all the appellees in this action. And the trial court's rulings should be affirmed in each instance argued by Ms. Heim. Ms. Heim additionally addressed all the failures of the appellant to address the essential elements of their claims. As to Ms. McGinley, there were 3 claims asserted against Ms. McGinley individually. And as to the motion for directed verdict granted by the trial court, that ruling should be affirmed because the appellant did fail to present any evidence whatsoever as to legal damages and of Ms. McGinley's knowledge as to the alleged issues appellant argues were not disclosed. Because those issues were not addressed and no evidence was presented or testimony, the trial court's ruling granting the directed verdict should be affirmed. Initially, as to the evidence of damages attributable to appellee, this has already been discussed quite a bit here today. And we'd certainly agree with the points Judge Kelly was making, as well as Ms. Heim, that simply there was no evidence of damages made in this case. The appellant appears to simply assert that a photograph showing a messy house and testimony by the appellant herself saying, purporting to say that perhaps Ms. McGinley should have known these issues was sufficient. But there was no actual evidence whatsoever that Ms. McGinley had any knowledge. And furthermore, these
It seems
matters
to
were
me
disclosed.
that, correct me if I'm misremembering the record, but I think the testimony about Ms. McGinley was that she walled in that fireplace shortly after she moved in to the house, shortly after she purchased it. And it had been, I forget how many years since that occurred.
Yes, I believe that's correct.
I don't remember the number, but a long period of time, however long she lived there, it had been walled up. So there really wasn't any evidence that she knew the condition.
Yeah,
I mean, she knew there was a fireplace there because she walled it up. But as far as the condition that around the fireplace, what evidence was there? I guess I should ask your opposing counsel that question. That she knew. She walled it up and forgot about it.
Exactly, Your Honor. That's the primary issue here, is that there is no evidence. In this case, the appellant had two witnesses who testified. Certainly neither could testify to the personal knowledge of Ms. McGinley or any other appellee in this case. And there was simply a failure of any evidence, testimony, documents, anything showing that knowledge. Furthermore, as has been discussed quite a bit here today, the fireplace was disclosed through the MLS, through Ms. McGinley's agent, through the inspection report. So these items were addressed. It's been argued that this hearing today and this appeal is about fairness. We'd argue the fairness is that a plaintiff in a case such as this has to prove the elements of their case. The damages and knowledge are essential elements to each of the claims against each appellee, including my client, Ms. McGinley specifically. And they've provided no evidence as to those damages or the knowledge. Additionally, as to the knowledge aspect, there is one matter that I believe does need to be addressed as far as evidence that was excluded at trial. And that's what's referred to throughout the record as the Massey documents and Massey records. These were records that appellant was hoping to rely on as far as trying to demonstrate some knowledge. But the trial court did properly exclude these Massey records. There were a couple primary issues with this. And essentially, the Massey records were relying completely on hearsay. And if you were to look at these Massey records that appellant was trying to argue should be admissible, the key statements and the key documents at issue, and just specifically what they involve were the affiant of the affidavit to admit that affidavit as to the business records was provided by an Adam Jones. Adam Jones was relying on the statements of a Don Fisher, who was therefore testifying as to statements of some identified person named Jim, whose statements were reflecting what my client, Ms. McGinley, said. So we're looking at essentially four-way embedded hearsay in one affidavit. And that's certainly inadmissible under any business record exception that the plaintiff is trying to rely on. The case law is clear, including in Knight versus GTE, the second DCA in 2018. Any business record still must account for hearsay statements within those records. And that's simply not done here. And the trial court properly ruled this way and ruled at record page 2856 through 2858 that these hearsay statements must be excluded. The trial court judge was going to allow the records themselves in, but those statements would have to be redacted, which is the proper ruling, as the hearsay statements must be excluded. There was additional argument made by appellant as far as the delay in consideration of that motion. It should be noted there was it was heard and it was filed a number of months before the trial. In each of the cases cited by the appellant as to a basis to exclude that the delay in ruling on the motion was improper, the cases cited all involve trials and judgments issued well after evidentiary hearings and trials, which simply isn't the case here. This was an evidentiary motion, and more importantly, as to fairness, the appellant was well on notice that this was a matter in dispute. The appellant, as throughout the case, had the opportunity to subpoena witnesses, had the opportunity to account for this. When we got to the trial date, the appellant well could have prepared for this eventuality that those records might have been denied, which was at all times a possibility. And so the trial court properly ruled that those records should be excluded. The trial court properly ruled that the appellant failed to meet significant burdens as to both damages, the knowledge, any negligent misstatements made by any appellee, including Ms. McGinley, and therefore the trial court's rulings should be affirmed. Thank you.
Thank you, Mr. Schmidt. Okay, Mr. Sanders, you're up. You have 5 minutes.
Thank you. So I'll start with the knowledge element. First, as to the Massey records being excluded, as I argued before the trial court and in my brief, Knight versus GTE is not applicable here. The difference being that there, the business record that was sought to be authenticated was created by a third party unrelated to the party that sought to proffer it into evidence. That's not the case here. Here, maybe it is hearsay within hearsay, but you can apply the business record exception to both the hearsay within the larger picture hearsay, which is what we sought to do here. The employee that made the critical notes was an employee of Massey who was conducting his routine business for the company, who in the course of doing the inspection made some notes, transmitted them in accordance with the company's policy. All this is in the affidavit, the business records affidavit, and it was kept in the normal course of business. So we met the burden for admissibility. Now, the jury could do with that whatever they wanted. They could certainly consider that, the employee that made the note, Jim, was no longer there. And maybe they, without hearing from him personally, directly, would disregard that. But it should have been admitted. And to hold off on making that decision, and having just said weeks prior, I'm leaning towards admitting them, clearly put us in a very bad state going into day 2 of trial. Otherwise, knowledge can also be shown by circumstantial evidence. In fact, it can usually only be shown by circumstantial evidence unless you happen to get a confession of the person that did the act. And here, for example, Your Honor mentioned the length of time between when the fireplace was walled in and when it was discovered. So if a fireplace sits idly, unused, unexposed elements behind a wall for a couple of years, there's no way to explain how it went from the condition that Ms. McGinley claimed that it was in, and she had a picture showing that it was in fine condition before she walled it in, and the condition in which Ms. Landon found it after she bought the house. Now, you can call it a mess, you can call it whatever you want. The bottom line is she had a right to know about it. And if she had known, and if she had had a chance to inspect it, she testified she would not have gone through with the deal. That's materiality. So even if we hadn't sufficiently proved a dollar amount, we proved materiality. And as to the extent that proving a dollar amount of damages, was not done, I've cited case law that says the inability to narrow it down to a specific dollar amount does not preclude recovery where it's warranted, which is certainly the case here. And we were denied evidence and the opportunity to question additional witnesses that would have spoken to that, maybe not to the satisfaction of the jury in the end, but we would have at least had that chance. The bench conference is the critical point here. I was very ill and I made the court aware of that. And then, for her to continue on rather than just letting us go right then alone is grounds for reversal under the cases that I cited. So then, yes, I did suggest, as I was in my state, my state of disarray, going through and trying to lay out what I was going to be doing for the rest of the week, I did make the comment that at some point I might rest and get what I needed from Ms. Perry on cross. But it was clear that I needed to still, at a minimum, question Ms. McGinley, Mr. Doyle, and the expert that we were trying to get. So to suggest that I make such a fateful course of action in my condition is reversible error, and it's why we did what we did. Now, again, blame it on me. It's my fault. This is not about me, and I can take it. And I certainly look back and learn from every experience I have, good and bad. I would not have made that decision.
Mr. Sanders, you said a couple of times, both in your primary argument and just now, that an expert witness that you were hoping to get. You did not have an expert witness ready to go for trial, correct?
We did. As Ms. Heim said, we did not subpoena him. He had appeared at our arbitration. There was no reason to think that he was going to be a no-show for the trial. Again, my fault for not subpoenaing him.
But when you say you were trying to, when you said you were trying to get another witness, was it? I don't know that the record explains this. Were you intending to get a different expert, or were you hoping to get the same expert to show up?
No, we were looking for an alternative.
Okay, and what authority is there for you to come up with a brand new expert during trial that had never been disclosed before, or discovery, the opportunity for discovery to the other side?
Well, I can't cite any support other than to say that I asked the court, would she consider letting us do this? She said yes. The other side had no objection. In fact, Ms. Heim asked for the opportunity to depose them before they would appear in trial, which we all agreed to. And I thought we were all operating under that understanding that was the end game there.
But at that point in time, there was no other expert, correct?
There was, and I mentioned the name on the records who I was trying to get, but we had not secured her yet. She had not officially said, yes, I will go do it.
Very good. That's all. That's what I wanted to make sure. Thank you.
Okay, Mr. Sanders, you need to wind up. Your rebuttal time is expiring.
Okay, thank you. I think I covered the points that that I wanted to make, so I'll just sum it up by saying again, we bring this appeal in the interest of fairness in real estate transactions and in our civil justice process. And for that, we ask the court to reverse the items listed in the appellate brief. Thank you.
Thank you. Thank you all very much. In order to leave our virtual courtroom, you need to find the leave button on your Zoom screen, which should be in the lower right-hand corner. And you click that and you go off into the ether.
Thank you.
Thank you.
Your Honors.
All right. Our next case is Ellsbury versus Moore.